Um, okay, so Ms. Dugas is on probation for the offense of robbery, a second-degree felony. We were previously here, and she entered pleas of true to counts 1 through 12, all of the counts in that motion, second amended motion to revoke unadjudicated probation. I received the updated pre-sentence report as well as a letter from Ms. Dugas. Has everyone had an opportunity to review that? Are there any additions or corrections?
None from the defense, Your Honor. No,
All right, and this was unagreed, correct? Ms. Holmes, you may proceed.
Thank you, Your Honor. I've spoken with Ms. Dugas. Obviously, the various new offenses and violations is not acceptable through probation. She understands that. She stated that throughout this time, she did not have much support. She was going through a hard time in life, and she resorted to doing and committing these offenses. Not being in obviously the right state of mind to be able to successfully complete probation. Ultimately, Ms. Dugas is requesting to have the opportunity to be reinstated to complete probation, and she would like to address the court in regards to this as to her plan of how she can successfully complete if given the opportunity.
Okay, go ahead.
There you go, Ms. West. Complete this probation. I know it's going to be extended if you do gratitude. My name is John. I'm great. I'm being like that on family. We'll never be found the world.
Ms. Dugas, you did the exact same thing. You robbed someone else while you're on probation for robbery. Not just rob someone else, you failed to ID, failed to report to probation, you committed the new offense of possession of a controlled substance, you resisted arrest or
Alright guys, today we are going to witness a courtroom moment where excuses completely collapse under the weight of repeated bad decisions, and the judge is clearly not interested in hearing another promise that has already been broken before Miss Dugas walks into court hoping for another opportunity on probation after violating nearly every condition possible, including robbery, drug possession, resisting arrest, and failing to report. And what makes this situation even worse is the fact that she was already on probation for robbery when she committed another robbery. The defense tries to explain her struggles, lack of support, and emotional state, but the judge immediately sees through the pattern because this is no longer about one mistake. This is about someone being handed chance after chance and continuing to ignore every warning that came with it.
It's ridiculous to me that you're saying you want a second chance, because this was your second chance. You've already been on probation. You were given the second chance of not going to prison. The fact that Ms. Holmes negotiated a cap of 8 years for you, you should thank your lucky stars. This is ridiculous. 8 years, in my opinion, is not enough. You had every opportunity to do all the things that stop crying, because you weren't crying when you were robbing people and using drugs and not being a good mom and not doing the things that you should have done when you were given this opportunity. Right? Ms. Malfino? Sorry.
I don't think I need to add anything to the court. I think that you follow the agreement that age at the very least is appropriate for her based on one of her violations. I spoke with Mr. Champ yesterday. He does not want to continue to work with her. This is actually her third MTRP. It's about her fifth chance in line abuse, not just her second chance in line abuse.
Ms. Dugas, I'm going to find that you entered your pleas of true to counts 1 through 12 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of robbery. Going to sentence you to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. I hope you take some advantage of this and actually do what you're saying you're going to do when you get out and change your life. There's programs in prison, take advantage of them, but you're not going to continue to get opportunities like this. If you continue to violate the law after this, you're going to be considered a habitual offender. And if you do anything again, your minimum punishment is going to be 25 years. 25 years minimum for what you've been doing. So you need to change your life or you're never going to see your kids, right? Go back with the bailiff.
Buckle up, guys, because this is the moment where the courtroom shifts from sympathy to pure accountability, and the judge absolutely unloads on Miss Dugas for wasting every opportunity she was given. Instead of accepting responsibility quietly, she breaks down crying, but the judge reminds her that those emotions never appeared when innocent people were being robbed and laws were being broken. What really stands out here is how the prosecution confirms this was far beyond a second chance, calling it more like a fifth chance due to repeated violations and failed attempts at rehabilitation. The judge finally hands down an 8-year prison sentence while warning her that if she keeps going down this path, the next punishment could start at 25 years minimum. This entire hearing became a brutal reality check, showing exactly what happens when probation is treated like a free pass instead of a final opportunity. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and now, we are now moving into the second case.
Good morning. Are you Wesley Antoine? And Mr. Antoine is here for sentencing on probation, a deferred probation for aggravated assault, family violence. And that was a 10-year deferred probation that he was given back November 14th of 2023. Entered pleas of true, it looks like, to counts 1 through 11. In the motion to revoke unadjudicated probation. I've received an updated pre-sentence report. This was an open plea to the court. Is that correct?
Yes, Your Honor. The court had previously, when we were here before, it advised the court, that he received 4 months on that new case in Louisiana, but it does involve the same victim, Miss Red, as his case here.
Mm-hmm.
We had discussed 6. The court did not feel comfortable with that, so we've just decided to go on to you.
Okay. All right. So that's what, and I wanted to remind myself, I had a notation on this about that new offense. So the new offense was in Louisiana, and it was domestic abuse, battery, also by strangulation, correct? Against the same victim. All right. Mr. Lewis, you may proceed.
Judge, in this situation, of all my conversations with Mr. Antoine here.
Alright guys, this second case immediately takes a darker turn because unlike the previous hearing, this one centers around repeated domestic violence and a defendant who was already given the massive privilege of deferred probation on a first-degree felony charge. The court lays out how Mr. Antoine admitted to violating nearly every condition of his probation while also catching a brand new charge in Louisiana involving the exact same victim and the exact same violent behavior. His attorney tries to explain the situation through mental health struggles, homelessness, and instability, but the judge is clearly focused on one thing: accountability, because when someone keeps returning to the same destructive actions despite multiple opportunities for treatment, support, and supervision, the court eventually stops hearing explanations and starts preparing punishment.
A lot of his issues come back to his mental health problems. And at the time, I believe he was not really open about getting the help that he needed with these issues. And once he got on probation, of course, those issues really became a very unstable situation. He admitted that he was homeless for a period of time there, which why he went back to Louisiana. All of his family is there. We had some sort of support system. But judge, he understands that he did mess up. He understands that, he hasn't done what he needed to on probation. He's taken it out for it. And he's just, at this point, he's asking for any consideration possible for so he can get out.
Thank you, Mr. Lewis. So on that original pre-sentence report, and the orders that went along with that, I mean, this is a first-degree felony. So on that deferred probation, It specifically ordered all the things that Mr. Lewis is asking for now. You've already had access to all of those things.
Buckle up, guys, because this is the point where the judge completely dismantles every excuse placed in front of the court and reminds Mr. Antoine that all the help being requested now was already handed to him long before this sentencing ever happened. The judge points out that he was specifically ordered into mental health programs, evaluations, and specialized supervision but chose not to follow through, and what makes the situation even more disturbing is the violent description of the original assault, where the victim was beaten with a cane and strangled while helpless on the ground. Instead of improving himself on probation, he allegedly tracked the same victim down again in another state and repeated the cycle of abuse. This hearing becomes less about sympathy and more about the terrifying danger of unchecked violence and repeated bad decisions.
Successful. But the fact that you're on probation, I mean, the allegations in this underlying case is that you had a cane and that you just beat the crap out of Miss Red with that cane while she's on the ground. And then you get out and you get around her again and you strangle her. I mean, it's just beyond me. That's where what you would do. I mean, it sounds like if you go to Louisiana, if you have support, that's great. But to go back and do that to her without permission, you weren't working, you didn't have your mental health, you didn't do your community service, you didn't do the batterers intervention prevention program, which probably would have taught you how to not beat on and attack and put your hands on people that you supposedly care about. Got a new offense over there for that. Anyway, I'm going to find that you entered your pleas of true to counts 1 through 11 freely and voluntarily. I'm going to find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault on a family victim. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the laws give you the right to receive. I believe the initial was yes. I am going to make the finding that there was a deadly weapon in that initial case. I'm going to hand you the trial court certification. You need to sign this with Mr. Lewis. It shows that this was not a plea agreement. You have some rights to appeal. You can talk to him about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Lewis. Good luck to you, sir. Sign that, and then you can go back with the bailiff.
Alright guys, this final stretch of the hearing delivers the harsh reality that was building from the very beginning as the judge officially revokes probation, finds Mr. Antoine guilty and sentences him to 15 years inside the Texas Department of Corrections. And you can tell this sentence was not only about punishment but also about protecting the victim from a pattern that kept escalating despite every warning and opportunity given along the way. The court also adds a deadly weapon finding connected to the original attack, which makes the consequences even more severe and strips away more future freedoms. This case is a perfect example of how deferred probation can completely disappear once repeated violence and noncompliance enter the picture, because eventually the court stops hoping for change and starts focusing on public safety. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we will see you in the next video.